Good morning, friends. This is the third lecture on common intention. In Mehboob Shah case, Privy Council said that common intention means prior planning of committing an offense. But the question arose how much prior it should be. Gujarat High Court in Oswal Danni case took the view that it must be anterior to crime. But how much anterior it should be, this was not answered by Gujarat High Court. The Supreme Court clarified the position in Pandurang versus State of Hyderabad. Many points were cleared by the Supreme Court in this case. Supreme Court said that prior planning means common intention. Common intention presupposes prior concert or prior planning of the offense. Plan need not be elaborate. A long interval of time is not required for hatching the plan, the court held. The plan may be hastily formed and rudely conceived. The plan or common intention may develop suddenly. The court made many more points clear. It further said that common intention will be inferred from the act or conduct of the parties and circumstances. Despite the clarification made in this case, a question remained unanswered. The question was whether common intention can develop on the spot. Virtually no gap between the planning and execution of the crime, that is to say, between common intention and commission of the crime. In Ram Tahal versus State of UP, the Supreme Court pointedly answered the question and said, common intention may develop on the spot. In gap in planning and execution does not matter because it may develop suddenly, it may develop on the spot. The court reiterated again, common intention will be inferred from the act or conduct of the parties and other relevant circumstances of the case. In Dharam versus State of Haryana, a new question came up before the Supreme Court. The question was that where common intention was to commit a minor offense and in course of committing the minor offense, a major offense is committed, whether all the accused who had formed common intention would be guilty of the offense or not. The court made it clear that once it is proved that the offense was committed in furtherance of common intention, it is immaterial whether in major offense was committed or same offense was committed. Even if a major offense has been committed, the accused would be liable of the offense. It is also no difference to say that accused caused injuries with lighter weapons or only caused light injuries or minor injuries. What is necessary is that there must be prior meeting of mind. Only then Section 34 will apply. Now the act must be committed in furtherance of common intention And suppose the charge does not specifically mention Section 34. The courts can take recourse to Section 34 even if the charge does not distinctly or specifically mentions Section 34. There is difference between common intention and same intention. Common intention means prior planning, means shared intention. The intention is shared by the accused in between themselves. In case of same intention, the intention may be same or similar, but it is not shared by the accused in between themselves. Say, intention to kill. X, Y, Z. Each may be having intention to kill, but this is not common intention. It is same intention. However, if X, Y and Z before committing the offense share this intention, then it will become a case of common intention. In same intention, the persons are accused may be guilty of different offenses and be punished accordingly. Now we come to the question of inference of common intention. How the common intention will be inferred? As said, that act or conduct of the parties, circumstances of the case. Thus, all the circumstances pertaining to the offense case have to be taken in totality. What was the conduct of the accused prior to committing the offense, during the commission of the offense, and subsequent to the commission of the offense? How the accused came at the scene of occurrence, how they mounted the attack, where the injuries were caused, what role was played by each accused. All these questions have to be taken in totality and considered, and then there can be determination of common intention. Common intention has been used in Section 34, but in Section 149 IPC, a new word has been used, common object. There, in prosecution of common object. Section 149 and Section 34 both become important so far as comparison between them is concerned. Section 149 says, if an offense is committed by any member of unlawful assembly in prosecution of the common object of that assembly, or such as the members of the assembly knew to be likely to be committed in prosecution of the common object of that assembly, all the members or every member who was member of that assembly at the time of committing the offense is guilty of the offense. In simple language, Section 149 says that where an offense has been committed by any member of unlawful assembly in prosecution of the common object of that assembly, every member of that unlawful assembly, irrespective of the role played by him, shall be guilty of the offense. The essentials of Section 149 are four. First, there must be an unlawful assembly. Second, the offense must be committed by a member of that assembly. The third essential comprises of two parts, A and B. A, the offense must be committed in prosecution of the common object of the assembly, or B, the members knew that such offense was likely to be committed in prosecution of the common object of the assembly. They, members, must be party to that unlawful assembly, or they must be the members of that unlawful assembly at the time of the commission of the offense. These are the four essentials. Unlawful assembly, offense committed by any member of that unlawful assembly, in prosecution of the common object of that assembly, all the members are guilty. What is unlawful assembly? The term unlawful assembly has been defined in section 141. It says that an unlawful assembly consists of 5 or more persons with the objects specified in that section. If 5 or more persons have formed an assembly to pursue the objects stated therein, this is unlawful assembly. Again, the same principle applies that even if the number of offenders is less than 5, they may be held liable for the offense provided that the actual number of offenders is more than 5 and it is proved that these persons who have been brought before the court had committed offense along with the offenders who could not be brought before the court. So actual numbers of offenders is more than 5, then conviction of persons less than 5 is possible. Otherwise, single person or persons less than 5 cannot be convicted with the help of section 149, and this was the view taken in a case Dharam versus State of UP. In that case, the court ruled that, and this is the modern thinking, that if the number of offenders is less than 5, simpliciter section would not apply. If the number of offenders is more and only few of them have been brought before the court, the conviction is possible. The offense must be committed by a member of unlawful assembly. Now, offense must be committed by any member of unlawful assembly, then all the members of that assembly would be liable. Here is a significant difference with section 34, because here mere membership is essential to hold a person guilty of the offense. It is not necessary that all the members of that unlawful assembly should participate in the commission of the crime. Then in prosecution of the common object, expression has been used. It simply means that there must be direct nexus or connection between the common object and the offense committed. There are some significant differences between section 34 and section 149. Section 34 is merely a rule of evidence, a principle of joint liability. It does not create a new offense. Section 149 creates a specific offense. It is not a principle of joint liability. It creates an offense and deals it accordingly. It is non-compoundable in nature. Then under section 34, it is essential to hold a person guilty of the offense if the offense has been committed in furtherance of common intention. Under section 149, all the persons would be guilty if the offense has been committed in prosecution of the common object. The liability under section 34 is founded on common intention, whereas the liability under section 149 is founded on common object. For the application of section 34, unlawful assembly is not necessary. For the application of section 149, application of common object, unlawful assembly is necessary.